So let me get into powers of attorney. What I'm going to talk about mostly are two different kinds of powers of attorney. We're going to talk about financial powers of attorney and healthcare powers of attorney. A power of attorney is a document whereby you, who's called the principal, authorize another person, who's the agent, to make decisions and take actions on your behalf. And both of these, you can do this in both a financial power of attorney and a healthcare power of attorney. Next slide, please. So what I often get is, why do I need these? What are they and why do I need them? So this slide, I want to talk a little bit about that. People often confuse, they say a living will, they think that a living will and a will are the same thing. And I get a lot of questions about that. So a living will is actually something that takes effect during your lifetime, where a will takes effect after you've passed away. A living will advises your physician what actions you want to be taken if you, the principal, are in a persistent vegetative state and you're not expected to survive. So it is a document that helps the doctors know what you want if you had a terminal illness and are going to die and can't tell them. So for some reason, you are in a persistent vegetative state, you can't tell them. That is a living will. A financial power of attorney allows someone to take care of your financial business when you're able to and when you're unable to. And I'll get to what that means in a little bit. But the financial power of attorney is somebody that helps you with your financial stuff, paying bills, doing things with the bank, paying your mortgage. A healthcare power of attorney appoints someone to make medical decisions when you can't. So let's get to, why do I need these? Most people think these documents are something that you need because you're going to die. And so a lot of people don't like to talk about them because they think, well, I'm not going to die anytime soon. I'm 20 or I'm 30. But things happen. Coronavirus is one of the huge things. We've had a lot of individuals who are very young, who have ended up in hospital, sedated, and on a ventilator as a result of coronavirus. If you don't have these documents, who's paying your mortgage while you're in the hospital? We're all hoping that when you come out and you are unsedated, you can take care of these things on your own. They're important not because people die, but because things happen that put people in the hospital and make them unable to do things for themselves. So the ability to appoint somebody else to take care of things while you're in the hospital is huge. Secondly, with regard to healthcare powers of attorney, which I will get into specifically what those mean in a minute, what I say to people is that the reason that healthcare powers of attorney are important is because you tell your family what you want done in a situation where you can't make those decisions. Imagine a situation where you have the coronavirus, you are sedated, and no one in your family knows what you want done. Do you want to be intubated? Do you want this medication? Do you not want that medication? So doing powers of attorney is actually something you do for your family as much as you do for yourself. Okay, so this slide, who can designate an agent? You have to be 19 years of age in the state of Nebraska. That means an adult. Nebraska is one of only 2 states that has the age of 19 as the age of majority. So you have to be 19 years old. You must have capacity. And what that means is you have to be capable of making the kind of decisions that you're granting authority to do. So you have to be understanding the decisions and the results of those decisions in the documents that you're signing. I often have folks who the person that's in the hospital doesn't have capacity, doesn't understand. And I get questions of, well, why can't I just have them sign this document? Because they don't understand it. And by law, they can't sign it if they don't understand it. Next slide. So let's get into that way. There we go. Important elements of powers of attorney. They're customizable. So you can put in them, as long as they go along with what the statutes in Nebraska say, you can put in them a lot of different things. What I'm going to talk about is Nebraska has actually 2 form powers of attorney. They have a form financial power of attorney and a form healthcare power of attorney. Those documents are what I'm going to talk about today. Once you have a POA in place, and I'm just going to, when I talk about POAs at the moment, I'm going to be talking about both healthcare and financial. I will get into the differences in a little bit. So if you have a power of attorney in place, its validity for the most part, is not going to be impacted by the fact that you lose capacity. So if you sign these documents, you're hit by a bus and you're in a coma, these documents remain in place. However, what does get rid of a power of attorney is the death of the person. If you die, your power of attorney is no longer valid and no one can use it to do anything. And if the agent, the person that you've appointed, no longer wants to act. The other thing that will take it out is if you revoke it. And there's a difference in revocability between a healthcare power of attorney and a financial power of attorney, and I'll get into that in a second. A power of attorney can be revoked by the principal. A financial power of attorney can be revoked by the principal at any time as long as they have the capacity to understand what they're doing. It should be in writing. It doesn't have to be, but it should be. Now, my slide says that a power of attorney can be revoked by a guardian or conservator, which is true. If the court appoints a guardian or conservator, the court can set aside a power of attorney and say that the guardian or the conservator can act regardless of the fact that there's a power of attorney. A power of attorney executed in this state is going to be accepted should be accepted in all other states. It's a rare time that I get to quote the Constitution, which is when all states, if something is valid in my state, it's a full faith and credit clause. If it is here, it's valid, then by the full faith and credit clause of the Constitution, it will be accepted in any other state. I get the question of an older couple that does their power of attorney here and then they retire to Florida. It's still going to be valid in Florida, even though it was executed in this state. Next slide, please. So as I said, the contents have to be with regard to what's in Nebraska statutes. And that's why the forms that the Supreme Court has put together are probably the best forms to use. I've put the link up there. This is the link to where you can find the form to both a healthcare power of attorney and a financial power of attorney. I always suggest that even though the forms are there, that you speak with an attorney to talk about these documents and what's in them, because the documents give great power to whomever you have appointed. And you want to make sure that you are filling out things the way that they should be filled out so that your wishes are actually being taken care of. It has to be signed by the principal, so you have to sign the document. Depending upon whether it's a healthcare power of attorney or a financial power of attorney, it's going to make a difference of how it has to be witnessed and or notarized. Next slide, please. So now let's get into a little bit of the distinctions. The healthcare power of attorney appoints an agent. You appoint somebody to make your healthcare decisions when you can't. It goes into effect when there's been a determination, usually by your healthcare physician in writing, that you do not have capacity, that you don't understand the medical decisions or the consequences of those medical decisions. And so the doctor at that point will invoke your power of attorney, and that person will then start making those decisions. I always tell people this is a fluid document. Again, we go back to you're hit by a bus. You're in a coma. You've appointed your spouse to be your healthcare power of attorney. Your spouse is then making decisions on your behalf. The minute you come out of that coma, the decisions go back to you. It isn't something that once those decisions leave you, they are no longer yours. Unlike a guardianship, where you would have to get the court order dismissed before the decisions would go back to you. It's another reason I like these documents. It's very fluid.
Hey, Ann, I have a question. Can people,
Sure.
if you're married, that you don't need that document? Because I think some couples may assume that.
So in the state of Nebraska, up until about 2 years ago, the truth was actually that there was nothing in the state of Nebraska that allowed for spouses to make decisions if there was no power of attorney or guardianship. About 2 years ago, the legislature passed the Surrogate Decision-Making Act, which does give a hierarchy of individuals that can make medical decisions if a person doesn't have a guardianship or power of attorney. The limitations to that document are, number one, that it does not allow for life-ending decisions. So if you were at the point that you need to make a life-ending decision, in other words, that you need to make a decision to withdraw life-sustaining treatment, that act does not allow for that. And secondly, it doesn't allow for financial things to be taken care of. So you can be making the medical decisions, but the person comes out of the coma and they're being evicted because nobody's paid their bills. So I would argue, and Margaret may disagree with me, but unless you have so much money that you're worried about inheritance taxes, I would argue that these documents are more important than having a will, because they are what help you when you are alive and help your family take care of things while you're alive and unable to make your own decisions. So a healthcare power of attorney can either be witnessed by two individuals, and it cannot be two hospital employees. I've had that question asked before. If you're in the hospital, one of the witnesses can be a hospital employee. The other one has to be somebody employed outside the hospital. And it can't be the person named in the document. So if you name me as your healthcare power of attorney, because I look like I'm really trustworthy, I can't be one of the people that witnesses the healthcare power of attorney, which makes sense, right? You don't want me saying, sure, she's given me that right, and being one of the witnesses. It can also be notarized. So the healthcare power of attorney, either you can do two witnesses or you can sign it before a notary public. A financial power of attorney is different in that it allows your agent to do financial things for you. And if you ever go on and look at the form, you can actually pick out specific financial things they're able to do. So handle your stocks and bonds, work with your bank. You can pick out specific things that your agent is allowed to do. It goes into effect right when it's signed. And that's another difference between the healthcare power of attorney. Healthcare power of attorney does not go into effect until you lack capacity. A financial power of attorney, at least the form we have in Nebraska, is valid the moment it's signed. It doesn't take away any of your rights, but what it does is allow someone else to help take care of things. As an example, I had a patient who had a stroke. She was able to sign enough where we were able to do the financial power of attorney, but she was going to be in rehabilitation for quite some time and she couldn't speak. They were just in the process of refinancing their home when she had the stroke. Because of the financial power of attorney, the husband was able to follow up on the paperwork, get the house refinanced, while she was able to just concentrate on getting better and being in the rehabilitation facility. So it didn't take away her rights. Had she been able to, she still could have gone and signed the documents, but she didn't have to because she gave him the financial ability to do so. The financial power of attorney in Nebraska has to be notarized. It cannot be witnessed. It requires a notary. And that's one of the other differences between the healthcare power of attorney. It has to be notarized. So typically when we do these documents, all of my staff are notaries. So we just notarize the healthcare power of attorney and the financial power of attorney at the same time. Next slide, please. So what are the agent's responsibilities? With regard to the healthcare power of attorney, it's their job to consult with the medical professionals and make decisions based on what they think the principal's wishes would be, not what their wishes are. And it's very important, I will tell you, when
Hey, I'm sorry, can you define agent?
So agent would be, if I appoint you, Tracy, in my power of attorney, you're my agent. I'm the principal. So once the principal, me, is determined to lack capacity, which is always an ongoing argument with people whether I have capacity, you could make my medical decisions. But it's your job to make my medical decisions based on what you think I want, based upon conversations that I hope you have with whomever you appoint. Have that conversation. I want to be intubated. I don't want to be intubated. I want artificial nutrition and hydration. So it is the healthcare agent's responsibility to make decisions based upon what they know the principal wants, what I want, and if they can't, what they think the best interest is, based upon their experience with the person, what they think their best interest is. This can include putting somebody into a skilled nursing facility or other appropriate facility. And that's the other thing with the, when you asked about decision-making, a lot of skilled nursing facilities will not take a person unless they have powers of attorney or a guardianship if they lack capacity, even though the Surrogate Decision-Making Act allows for placement decisions. So that's another reason it can hold a placement for an individual. So occasionally These documents also require or allow you to make life-sustaining or withdrawal decisions. So you may be called to, as an agent, to make the decision, I hate to use the term unplug, but that's how we always, to make that decision, to terminate or withdraw life-sustaining treatment. So don't pick your spouse because you think your spouse is a great person if you know your spouse isn't going to be able to make those decisions. Pick somebody that you know will make the decisions that you would want made. Financial power of attorney, it is your job to act in the good faith of the person who's appointed you. Don't steal their money. Don't tell people when they're signing things. I always tell people, if you're signing a check as the power of attorney, sign it your name and then power of attorney. So people know the capacity that you're acting in. Just make sure that you are doing things as you should for the best interest of the person that you're doing work for. Next slide, please. So what are the agent's limitations? You can't act outside the scope of the authority. So again, as I said, the financial power of attorney especially, it has categories of things that you can initial that say this, okay, my agent can do this, my agent can do that. If that person has not initialed a specific power, you don't have that power and you can't do that. With regard to the healthcare power of attorney, your limitations are whatever is in that document. Nebraska specifically says that unless you are actually authorized to make a decision with regard to withdrawal of life support, you don't have that authority. With regard to the financial one, don't create a conflict of interest. Don't do something where it is in your better interest than it is the person you're working for to do things. And that's just common sense. Your limitations are, don't do stuff that you wouldn't do if this person was alive and standing in front, or was awake and standing in front of you. Act as you should. That is all I have with regard to those, unless anybody has any questions before we move on to wills.
I think we are good to keep moving.
Good.
Okay, that moves us off to me. I like to talk about the stuff that Anne has shared on powers of attorney as the before stuff, the while you're still here stuff. And the section I'm going to talk about is what happens after you're not here anymore. And I think since all of us have experienced what it is to be alive and to take care of our business, it can be a little bit of a trick to think about what happens when I've passed on and I no longer have the ability to let people know or to talk or to share or do anything at that point. Now there's a couple of technical terms and things that people get a little confused about. First of all is a will. A will is simply a document that states how your stuff is distributed after you die. And you can nominate someone to serve as a guardian for your children. And you nominate a personal representative, and I always recommend an alternate just in case, that takes care of business for you. Now, wills do need to meet legal requirements. We're going to talk about how you can get one of those through legal aid and our partnering agencies in a bit. They're not a do-it-yourself proposition, and I don't recommend you go online and find some form that somebody's selling. It's something that needs to be specific to the needs of what you have. But basically it says who gets your stuff after you pass. Next slide. If you don't have one, then the law says who gets your stuff. Pretty straightforward. It's very much like that substitute decision-making statute that Anne talked about. The law sets out, if you die, who's going to get it? If you have a spouse, what do they get? If you have children with that spouse or children with someone else, who gets what and how much? If you don't have a spouse, you don't have children, then do you have grandchildren, or do you have parents or siblings, however your situation is. So the intestate succession statutes are going to have an estate plan, as it were, that's different for each individual, depending on who you leave behind. So you want to look, if you don't have a will or someone passes on that you are related to and they didn't have a will, you want to pull out the statute and take a look at it, and we can help you to do that. Next slide. Now, sometimes property is titled. Real estate is titled. Cars are titled. That's what I mean by having a titled property. When we're talking about real estate, if a married couple owns a house together, it's generally going to be held as joint tenants with right of survivorship. So my husband and I own our home, and if he was to get hit by a bus, we have a lot of buses out here, and he was to pass on, I would take a death certificate down to the county, and I would be able to file that, and now the house is mine. That's joint tenants with right of survivorship. Sometimes property is held as tenants in common. Let's say me and a friend got together and we bought a house together, and we're roommates and we share this house, and it's half mine and it's half hers. But if she was to pass on, if we owned it as tenants in common, her heirs, or the people she names in her will, would inherit her half of that house. It wouldn't be mine. So it's a different way for property to pass after you pass on. Next slide, please. You can, in the state of Nebraska, sign what's called a transfer on death deed. This is a wonderful mechanism, and it's only been allowed, I'm not sure exactly how long, maybe 5 years or so. The transfer on death deed makes it easy for real estate to transfer after death. So if I own my house alone, I had already taken my husband's death certificate down, and now it's my house only, and I was to sign a transfer on death deed to my son because I wanted him to inherit it. I would not be changing title as far as who owns it now. This is still my house. I can mortgage it. I can sell it. I could buy another house. I could repair it. As a matter of fact, I'd have to pay property taxes. It's my house, my responsibility. But if I was to pass on and there was a transfer on death deed to my son, then he follows the same process that I did when my husband passed. He takes my death certificate down to the county, and now my house is his. Next slide, please. Other property passes in a similar way. So for example, if I have a life insurance policy and I name a beneficiary, or investment accounts that have a beneficiary or a payable on death, then that property goes to the person that I've named after I pass on. So I have at Legal Aid of Nebraska a life insurance policy. If I die, it goes to my husband. If he's already passed, it would go to my children equally. No problem, no muss, no fuss. A death certificate to show that I have indeed passed is all that is necessary for my beneficiaries to claim the property, the life insurance policy or investment account or whatever else it might be. Next slide. Now you can also do a transfer on death title for your vehicles. It works exactly the same way, and the DMV website has a form that you can use. And that allows for a car title to pass as easily as any of these other assets to whoever it is that you say gets the car after you pass on. My daughter loves the Honda that I drive. So if I was to put her on as the person to get my car after I pass on, if I died, she takes that death certificate down to the DMV and gets a title in her name, and now she has my Honda. These do have filing fees and such, but it's not terribly expensive. Next slide, please.
Margaret, I have a quick question.
Okay.
If you have a will, do you need to do all these individual forms to make sure that your things are passed down to the right people?
Well, technically, no. But it's the process of transferring these that can be much simplified for the people that are left behind. Okay. So if you have a will that says my son gets my house and my daughter gets my car, then they might need to do a probate or a small estate affidavit. And I'm going to touch on those in a minute. But it's more expensive and it's more complicated and it takes more time. Now, jointly owned bank accounts are fairly straightforward. If I and my mother own a bank account together and my mother passes on, that is now my bank account. We see this a lot with folks that are helping take care of mom. Maybe they are the ones that are writing out the checks and paying the bills and that sort of thing. And so mom says, I'll just put you on my account. It'll be a lot easier for you if you're just an owner on the account. And people do it all the time. And in some circumstances, that works fine. But if mom's only asset is that bank account, and only one of her children is on that account, and her will says, I want all of my stuff to go to all 4 of my children, when she dies, that account is now owned by the co-owner, who is not legally obligated to share with his siblings, and they may or may not. Some siblings would say, mom wanted us to share the money in our account. I'm going to write you a check. And some might say, nope, this was mine. I'm not going to share it with you. It really depends on your family dynamics and who's on that account. The other caution about adding someone to a bank account to make it easy for them to write checks for you is they can take all of the money in that account. And hopefully they wouldn't do that because you wouldn't put somebody on that you didn't trust. But I get a lot of calls from folks who have that kind of a situation. The other issue is if that second person is sued for a debt, they may attempt to garnish your bank account. And there might be some protections for that, but maybe not enough to protect the money in your account. So we always want to be careful about jointly owned accounts. But I know it happens a lot, all the time. And in many families, it works out just fine. But you gotta know what you're doing to do that. Next slide, please. Probate. Probate is a scary thing for a lot of people, but it really isn't all that difficult. Probate is, however, expensive. If I was to, let's say my husband and I own our house together, and we were to both pass on without making any changes to that title or house. And we both got COVID, for example, and we both passed on, and now our house needs to be transferred. We didn't do a transfer on death deed, we just owned our house. Now we had a will that said our house goes to our children, but we didn't change title in any way. They would go hire an attorney who would file papers with the court. And the court would then collect any claims anyone had for our medical bills or our credit card bills or whatever else we had. The personal representative would pay off all of the debts. The house maybe gets sold because there's some debts to pay. And then once that's all done, then the proceeds would be distributed amongst my 2 children. And 6, 8, 12 months later, they pay the final bill to the attorney and it's all done. So probate, while it's necessary in a lot of states, is kind of a pain. If your property is worth less than $50,000 in total, you can avoid a probate with a small estate affidavit. So next slide. A small estate affidavit can be used for real estate or personal property. Personal property is just not real estate. And it's used to transfer money to either your heirs via intestate succession or the people that you name in your will. There are certain requirements. Everybody's got to be getting along, because if people are complaining at each other about who gets what, that's not going to make it for a small estate affidavit. You need to wait 30 days after death. There must not be a probate going on. And anyone who has an interest in the property has to sign the affidavit. So I'll get circumstances where mom's passed and there are 6 kids in 6 different states, and they need to transfer or cash a check for $1,000 that was a rebate for mom, or what was left in her bank account or something like that. They got to send and go throughout and get signatures from all 6 kids so we can get that check taken care of. But it's a heck of a lot easier than doing a probate. Now, if mom had creditors, they could come after the heirs or the beneficiaries for the amount of the property they inherited. So if I inherit $1,000, use a small estate affidavit, I get that $1,000. And then Capital One says, oh, you owe us $500 from the bill that your mom had. I would be liable up to the amount that I got. Now, if mom owed $10,000 to her credit card and I inherited $1,000 from her bank account, I'm limited to that $1,000 that I received from mom's estate. Next one, next slide. Debts that someone have are not inherited. Credit card companies may try to convince folks that they need to pay their parents' bills. I've talked to sons and daughters and nieces and nephews who say that collection agents have contacted them and said, well, what are you going to do about your mother's credit card bill? There's only one real answer when there is no estate, as often is the case, and the answer is nothing, and to hang up. Now, if there is, as I said, any debt, any estate, any value there, then you would need to pay up to that amount of the value. But if there is no estate, then the heirs do not inherit the debt. I have elders who call the elder access line that are just terribly worried that if they pass on and credit card debt or something like that, that their heirs are going to have to pay that debt. And it is a relief for them to find out that they don't. But if you inherit property that comes with a liability, a secured interest, like a mortgage, then that mortgage still needs to be paid because that is a secured item.
Margaret, somebody did ask about student loans. Are student loans inherited?
No.
Okay.
So if my son inherits my house or my children inherit my house, they would have to pay off the mortgage in order, or they probably would sell my house and pay off the mortgage and split the proceeds. They don't want to live in Fort Calhoun. So that would be the likely answer here. Okay. Next slide. Trusts. Trusts used to be a lot of marketing around trusts. There's some trust companies like to do these lunches where you come in and they tell you about trusts and they educate you and then they try to sell you one. It's a good deal for the attorney, I suppose, although I haven't written a trust in a very long time. And it is a way for people to avoid a probate. And if you have substantial assets and need to do some good estate planning of how you skip generations and deal with estate taxes and inheritance taxes and those sorts of things, a trust may make a great deal of sense. Prior to the transfer on death deed, it made good sense for transferring a home without a probate. And in that circumstance, it made sense. You pay for a trust now rather than paying for a probate later. It saves your heirs trouble and expense. But with a transfer on death deed, that's often for someone who the home is their only asset, makes a lot more sense. You can also limit the ways that your heirs can receive or use the funds. So if you are leaving money or assets to children, trusts make a lot of sense. Or if you want to set up some kind of a way that money is used for educational expenses or something like that, trust may make really good sense in that circumstance too. There's also what's called a special needs trust. And a special needs trust allows someone to leave assets to someone who is disabled, that allows them to get some benefit from that without losing their public benefits, their Social Security or Medicaid and things like that. If you do decide you need a trust, that is something you need a private attorney to assist you with. Again, not a do-it-yourself proposition. And unfortunately, Legal Aid of Nebraska does not create trusts generally. Next slide. What we do at Legal Aid of Nebraska is we serve mostly low-income people or people 60 years of age and older. We provide a great deal of legal advice. We can provide forms and links to online forms. For wills, we can prepare simple wills. We often partner with the Creighton Legal Clinic and the Volunteer Lawyer Project for them to help with some of those wills. They look for private attorneys that can provide will writing. But sometimes we do them ourselves. We do them through the Elder Access Line that I manage and through the Help Project that Ann does.
Margaret,
So,
what would be an estimated cost to have any of these documents drawn up?
okay. If you need a power of attorney and you qualify for legal aid services, which means you're 60 plus or low income, free. If you qualify for a will, and it's a very simple will, and we can do it at legal aid, free. If you need to go to a private attorney for assistance, I don't know what those cost. But if you qualify for our services, which generally is low income or 60 plus, we don't charge anyone for any services ever. Now for transfer on death deed, while I am a proponent, I don't prepare them. Sometimes we can ask Creighton or VLP to do those, and sometimes they're able to. But if they are not able to do them, that would be a private attorney. I don't know what they charge. I can't imagine they're hugely expensive. It's not that hard.
Okay, we have a few more questions coming in. Where can you go if you don't meet income requirements? Any recommendations? I know you said that you do have referrals for wills and partnering.
Yeah.
Okay.
Yeah, and if we can't do it, if it's not something that our partnering agencies can do, any Find a Lawyer is through the Nebraska Bar, and it's a website that allows you to look for lawyers that have different areas that they practice in. I recommend someone look to an elder law attorney, and there are several in the area. I can't be specific on who, that can look at your estate. If you've got some assets and you want to be doing estate planning, you need to be thinking about long-term care and what your needs might be as you age, and they can help you to look at Medicaid planning too.
Okay. Someone asked, can you avoid estate taxes by using a transfer on death deed?
No way to avoid the tax guy. But estate taxes are what we're talking about is federal taxes, and you got to have quite an estate for that. There are some inheritance taxes in Nebraska, which is a little bit different, but you know, people talk about death tax and estate tax, but you got to have, I don't even know if there's, I mean, it's not anything that any of our clients are going to need to worry about.
Awesome. Okay. Someone did in the chat window said that they encourage people to shop around. There's a wide range of prices when it comes to fees. So make sure.
And you want to work with somebody that you trust and that you can feel like you can talk to. And that's really important to be able to communicate what your needs are with a lawyer that you're working with. Now, if you need assistance from legal aid or you want to see whether you qualify for any of these services, the statewide access line hours and phone number are listed here. But if you are 60 plus, call our elder access line. It's open some more hours. The other area that I want to kind of point out a little bit is if you own Native American trust land, that is an area our Native American program can help with. Those folks really do need a will, and we can help you to prepare that. Again, if you meet the requirements for that program. Other questions?
We have another one. Are the transfer upon death deeds / titles something unique to Nebraska, or do other states have them too?
Some do, some don't.
Okay.
I know that it's been a struggle to get them adopted in some states. I was on a listserv for a number of years in California. They'd worked for decades and hadn't got it passed. Here in Nebraska, it passed fairly easily in just a couple of years. I don't know the number of states that have them and those that don't, but it's not every state.
Okay. Is there, and you may or may not have this answer, is there a website or someplace people can go to find that answer easily? Or do they just?
Trends on death deeds in other states, I don't know.
Okay.
But I do encourage you, if you have legal questions, to go to our Legal Aid of Nebraska website, which is just legalaidofnebraska.org. We have a wealth of information there about a variety of legal subjects, including a ton of stuff on COVID-19. And some of the forms are available on that website. Maybe a little tricky to find. We can help you to do that through the hotline.
Okay, a couple more questions still coming in. We're going to get to as many as possible. To clarify, if someone is 60 plus, their income is not considered for legal aid. Is that true?
You can provide at least advice and forms, regardless of income, for people 60 plus.
Got it.
We may not be able to take on the case or do extended representation for someone who's over income. We can do advice and forms.
Nice. Someone else listening in from Habitat said his advice was don't wait. Talk to your kids and or your parents now. It will help upon death. So
yeah.
I will say oh, go ahead, Margaret.
I tell my clients, you tell them that lawyer lady said we have to talk about this stuff.
My children, the moment they hit 19 years of age, both had powers of attorney, because I've seen how many, what this does when families don't have those. So yeah, it's even for young people, they're important.
That's interesting. I hadn't even thought about it for a 19-year-old, but you're absolutely right. Decisions have to be made.
Yeah. I have my kids sign them for sure.
That's smart.
And they know where the financial papers are, and they know what kind of medical care I would want if I was seriously ill with COVID, because we've just had that conversation, and we continue to have those conversations.
Wow. What is considered low income, someone is asking?
Well, that's a complicated question. Our income and asset guidelines are based on household size and federal poverty guidelines. There's some things we count and some things we don't. So if you're not sure, give a call. If you're over, we'll calculate it and let you know.
Okay. Another question. What if a person is divorced? Does their ex-spouse have to be part of the will preparation?
No, not if you're divorced. But if you are married to someone, the law does protect that spouse, and you may be limited in disinheriting them if you are still married.
Interesting.
I'm wondering if that question is stemming from children and guardianship of children. And so if that person has, if that's what they're talking about.
Yeah, I bet it is. Where do the kids go? If somebody has a will, they want the kids to go.
So I get that question a lot because people will say, well, I don't want that no good so-and-so, my ex-husband, so I'm putting in the will that, Margaret gets my kids. Nope, the biological parent gets, if I'm divorced and my children happen to be minors, regardless of who I put in my will as the guardian, those kids go to my spouse unless he predeceases me or he doesn't want them, which some days when they were teenagers, I'm sure that would have been the case. And so I always say name somebody in there, but they go to the other parent or the biological, adopted, etc.
And the follow-up, even if there's not a joint custody plan?
Correct, because they're the parent. So regardless of what the custody plan is, and I have to tell you, that's one of the important things, and I don't want to get into big custody things, but when you do have instances where perhaps parents are divorced and maybe the one parent has absolutely no contact with the children or is abusive, or it is important at that point always to appoint someone in your will as the guardian, just in case, in the case of married people, if you both die in a car accident, or that person can then step in and they would have to go through a court action to try to get guardianship over those kids, but you appointing them in the will serves as evidence as to why they would want that to happen.
Okay, so another one. So we shouldn't just do our own will at any time. Only through an attorney is what you suggested, correct?
That's correct.
Okay. I have a death upon deed already done on my mom's house, plus my name is on her account. Is that all I need to have done?
Depends on what your mom has when she passes.
Okay.
I like folks to sit down and think about, what do you have? If there's titled assets, are there accounts, are there financial instruments? Sometimes families will want to designate particular personal items. My opal ring goes to my granddaughter, my, whatever things you might have that are for particular people. That's a good thing too. But you want to make sure that you have identified, what are we talking about? It's also good to keep in mind, sometimes there are surprises, and that's where the small estate affidavit comes in, that rebate check you didn't know about, the account that mom didn't tell you about.
Right.
My husband and I went and listed our things for our kids. This COVID stuff has us a little spooked.
Yeah.
And next day realized I have a health savings account. I needed to list that too. So is there an asset that you haven't thought about?
Okay. We have about 5 minutes left. And if their home is their only asset, their only real asset, then that transfer of deed at death would probably be the best option,
I
correct?
love them. I think they make good sense.
Okay.
They're easy, no fuss, no probate way to transfer title in real property.
Okay. And then one more question here. What is the name or the kind of lawyer that does wills or POAs, etc.? What should I Google for to start?
So I would suggest you go to the Bar Association, but you're going to want an estate planning attorney
Estate
or
planning.
an elder planning attorney, either of those terms. But I would go to the Nebraska Bar Association before I'd go to Google.
Yeah.
Okay. Ladies, this has been invaluable information. Thank you so much for taking the time this evening and your willingness to share your expertise on such an important matter with all of us. Again, I want to thank all of our partners, Legal Aid of Nebraska, Creighton Legal Clinic, Volunteer Lawyers Project, University of Nebraska Lincoln Law School. If you would like more information about any of Habitat Omaha's programs or still have questions as a homeowner, and still trying to figure out where to start, you can feel free to reach out to our Habitat staff. We have 2 people, David Klitz, a program specialist. And Lacey, can you put that slide back up just so that people can see it one more time? And Lacey Studnicka, our program director, who is also our host ghost. She's in the background pushing all the buttons and the one who organized and made this happen. So special thanks to you, Lacey, for making this happen and for pulling all of us together with this great information. Please remember there will be a recording available if you would like to review this information. And thank you again for joining us, and have a great evening and stay safe. Stay safe.